Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome to the Baker Botts Enforcement Insider, a podcast covering the latest trends and developments in compliance and enforcement with a focus on the energy and technology industries. I am Michael Loesch in Washington, D.C., and we will be joined a little bit later, as always, by Brendan Quigley from New York. Brendan's tied up at the moment, but will be joining us late. We have an exciting topic to dig into today. We're going to examine the impacts from the recent election and the potential legal and regulatory changes that could arise under a Trump administration, and also examine a little bit how that will be affected by the outcome of the U.S. Senate and House races. We'll be focusing on enforcement investigations, as always, and we will cover the CFTC and the SEC. But first, we are delighted to have two guests to the show today who will help us cover issues regarding environmental law and policy. Today, we're joined by Baker Botts partners Sahay and Jeff Wood, who are part of our environmental and energy teams in Washington, D.C. Hello, gentlemen.
Hey, Michael. You're great to be here.
Yeah, we're excited to have you. So I didn't give any intro bios. We're happy to just jump in, or if you'd like to say a tiny bit about yourself, I'll throw to you first.
Sure. Well, thanks again for having me on the podcast. Really excited to be here. So I am a DC regulatory lawyer. I spent a lot of time on energy transition issues. I spent 6 years in-house in the biofuels industry, where I was the lead regulatory and policy counselor for the largest biofuels producer and general counsel of the largest biofuels trade association. But really, I have a much more diverse practice than that, ranging from more traditional environmental law, environmental audits, Clean Air Act, Clean Water Act, TSCA, kind of the full spectrum, all the way again to a more recent focus on energy transition issues, do a lot of work with the IRA and renewable fuel standard, low carbon fuel standard, things like that these days. Thanks again for having me on.
Yeah, sounds great. A lot of firepower. Jeff, how about I turn to you?
Well, thanks, Michael. Really glad to be part of the discussion. I'm in my, 21st year of environmental law practice. I currently have the privilege of chairing our firm's DC Environmental Safety Incident Response section. And prior to joining Baker Botts around 5 years ago, I had most recently served for 2 years as the acting assistant attorney general for the Justice Department's Environment and Natural Resources Division. That's the division within DOJ that handles all the environmental enforcement cases that are brought in civil and criminal proceedings in the United States. So really privileged and honored to have had that role. I previously also served on senior staff of the U.S. Senate Environment and Public Works Committee, and also spent about 4 years in-house with a major maritime company. But really appreciate the opportunity to be on here. Look forward to the discussion.
Great. Thank you both, Shay and Jeff, for joining. We're going to get to the SEC and the CFTC later, but let's just jump right into the environmental law issues with the two of you. Shay, why don't we start with you, and maybe you can just give us your take on the 2024 election and its impact on environmental regulation.
That sounds great. I think there's two places to start. One is the leadership that President Trump has nominated for EPA, DOE, DOI, and other agencies. So we can kind of chat a little bit about that, and then also talk about the key themes that are emerging as energy dominance and deregulation. But I'll give away the conclusion, which is things are going to be, I think, harder to predict than one might assume with this administration. And again, going back to this leadership cast, it quickly becomes obvious why the interaction between these folks is going to be complicated and potentially result in some unexpected outcomes, I think. So first, you've got Lee Zeldin, who is in charge of EPA. Lee Zeldin is obviously a former congressman, Chris Wright, who's an energy industry executive in charge of DOE, Doug Berg, also with an energy background, also governor of North Dakota, who's in charge of interior, and then Elon Musk, who is in charge of the Department of Government Efficiency, and then RFK, who's coming in at HHS. I also think he's somewhat relevant given his background and interest in the chemicals areas. But that group, I think, is interesting. And in some ways, some of the things that they focused on in their career cuts against some of the stereotypes you might expect with a Republican administration coming in. And then in terms of areas, I can kind of
Hey, before we get into areas, let me ask Jeff. Jeff, with your time on the Hill, you were on the Senate side. What do you think? Are these going to be ugly nomination fights, or do you think the team that Shay described has good odds of getting through? You pull out your crystal ball.
Yeah, I wish I could say for sure, but I know that the picks there that Shay just went through, Congressman Zeldin, I think he'll have a good chance of some bipartisan support, actually. I suspect he'll be confirmed. Mr. Wright as well comes with a strong energy background, certainly knows the energy sector. And so I wouldn't suspect that he'll have difficulties there. Now, of course, Governor Burgum is also very well known. I suspect he's very much in the mold of previous interior secretaries as well. They have a significant role in the energy realm. With regard to Mr. Musk, I don't think he's got to go through confirmation because this is an external role. I think that's a really interesting dynamic to watch. But those three, I suspect, would get confirmed in the early stage of 2025.
Sounds good. Shay, do you want to pick it up? So I interrupted your flow.
No problem. Please feel free. Again, like two of the themes that I had mentioned are energy dominance and deregulation. I think we'll see those themes weave their way into a number of subject areas. One of the things that folks expect will be a high priority in terms of deregulation will be a rollback of some of the greenhouse gas regulations that EPA set forth under the last administration. There was a rule governing power plants and then a rule governing emissions from vehicles. The power plant rule essentially required the installation of carbon capture and sequestration equipment on a number of categories of power plants. And the tailpipe rule, the only way to comply with it is to essentially sell more electric vehicles as part of the mix of vehicles in the United States. And then there's another rule related to that. It's called the California waiver. It's the mechanism by which California is allowed to set its own standards for vehicles, and their standards are even more aggressive than the federal standards in terms of promoting electric vehicles. So everyone's expecting these rules to get pulled back first thing. But of course, one big question mark there is that Elon Musk has a heavy role and he makes electric vehicles, right? So I think there's a big question like, okay, how is this going to play out? Everyone's expecting this to be a high priority. On the other hand, someone with a really key role in the administration is a real proponent of EVs. So it'll be interesting to see how the role of EVs emerges in this administration, whether it impacts the manner or the speed by which the new administration pulls back on the climate rules and the California waiver in particular. Another kind of interesting area to start the conversation, and then I'll flip it back to Jeff for his thoughts, is with the Inflation Reduction Act. This was hailed as one of the Biden administration's biggest achievements, and some folks have been talking about is the Trump administration going to come in and try to repeal the IRA. And I think some of these tax credits that are in the IRA have such broad appeal that they're going to be relatively difficult to repeal. So, for example, there's the 45Q carbon sequestration tax credit. Doug Burgum was a big I think he's been on the record as not being an IRA supporter. On the other hand, he was a big proponent of carbon sequestration in North Dakota, and that state really set itself up to be a national leader in carbon sequestration. You've got the 45D hydrogen credit. There's a lot of states where Donald Trump won by a large margin, where a lot of the hydrogen projects in the United States are taking place or where they're planned to take place. So given the stakeholder group, there's some question whether the administration really is going to want to pull back on the clean hydrogen tax credit. And then there's a clean fuels tax credit, same thing. There haven't even been proposed rules on that yet, but there's reason to expect that the administration wouldn't take away what's seen as a pro-farm tax credit. Those are a few thoughts on a couple of programs. Jeff, I don't know if you had any reaction to that or thoughts on things that'll be immediate priorities over there.
Yeah, I think you've hit a lot of high points. One of the things I think about is what tools are available for a new administration that wants to change course. And I think this administration, like others before it, will want to take advantage of every tool at their disposal for changing the direction of environmental law, policy, and particularly in the energy and technology space. But I thought I might just briefly comment on that because I think our audience may want a refresher on that. First of all, we would fully expect President Trump to issue a series of executive orders in the very first week of the new administration, if not the first couple of weeks, directing the agencies to review, reconsider, and as consistent with law, modify or repeal the long list of regulations adopted during the Biden administration that are inconsistent with the policy agenda of the new administration. A lot of those are things you've mentioned, Shay, in your list there. One thing to keep in mind is that you can't just snap your fingers and suspend a rule, especially one that is already in effect. And so the new administration will have to be careful as it moves forward, ensuring that rules that were previously adopted, to the extent they're going to be rolled back, that occurs in a process that's compliant with the Administrative Procedure Act. Some interesting new developments in terms of the law out of the D.C. Circuit on that. In a 2022 decision by the D.C. Circuit, the court clarified that to the extent an agency has already posted a regulation for public inspection on its website, even if not yet published in the Federal Register, that's enough to restrict a new effort to suspend that rule. You have to go through APA processes to roll it back. So be looking at the sort of end of the current administration as we get into mid-January for those new rules to be posted on the Federal Register website, even if not yet published. And that'll make it a little more complicated for the new administration to come in and pull those back. In terms of setting new priorities and new policies, I think you're right, Shay. There's some new players. There's some new dynamics. Trump 47 may not be exactly the same as Trump 45 on the environmental and energy front. Certainly, the president during the campaign talked about speeding up oil and gas production, talked about promoting nuclear power, talked about ensuring that the U.S. had strong strategic petroleum reserve volumes, things like that we can expect early action on. If you look back to 2016, a lot of the conversation was around the notion of a war on coal. And I think the 47 policy view may be a bit broader in terms of promoting an all of the above energy expansion policy agenda. And then when you think about what options are out there for a new administration to manage the path forward, there's a lot of these regulations adopted in the Biden era that are already in litigation. And so the new team there at EPA and other agencies will obviously look to use the APA provisions that allow for a stay of regulations pending judicial review or take full advantage of that, as well as asking courts to remand recent Biden era regulations, to remand those back to the agency for reconsideration. Most of those remands will likely occur without vacatur, although they may, in some cases where they think the legal position was highly suspect, may seek it with vacatur. But I expect most of this to be without vacatur. That's the lay of the land. I did want to just note one last thing, Michael, that this is the first new administration under the Loper-Bright era. This will be the first time a new administration enters and since before the 1980s, when they won't have the sort of traditional Chevron two-step approach for adopting regulations. They won't be able to say, even if it's not the best and correct interpretation, we think it's a permissible interpretation. They'll have to put forward the best and correct view of a statute. And I think that actually presents some challenges for any new administration, because they've got to take a harder line on what the law allows them to do or requires them to do, and doesn't give them quite as much flexibility. I think that's one of the interesting things to watch as this plays out.
Yeah, let me just ask you this. There's a lot embedded in there as to how this may all play out and the different tools and mechanisms. From a company perspective, a company with interests in either direction in these policies and laws, seems based on the need for continued reliance on the Administrative Procedures Act, that there still is going to be a lot of opportunity to provide comment and present views to try and impact the process. Am I thinking about that right?
Yeah, I think if in most cases, the new administration is going to need to follow public notice and comment procedures before changing course. Certainly policies and priorities, those can change much more quickly. You can direct activities. You can ensure that programs have the level of engagement that you want them to have as the new administration, because elections do have consequences. But when it comes to changing the regulatory regime, that takes time, and it takes public engagement, and the APA requires you to cross your T's and dot your I's as you move forward in that direction.
Yes, certainly a reason for interested market participants to remain engaged and be a part of that process where it makes sense.
One way in which Loper Bright is going to change things, and Jeff, you alluded to this, is that in the long run, we're going to have to wait for a lot of these things to be adjudicated. But in the long run, there should be less oscillation between administrations in terms of how these laws are interpreted. Because as Jeff pointed out, we're no longer talking about a reasonable interpretation of the law within this range of possible interpretations. We're talking about, well, what the law means. Now we have to, on some of these laws, we'll have to wait a while until judges tell us what they mean. But once we have a clear idea of how judges fall on these issues, administrations won't be able to go back and forth as much when they switch between Democrat and Republican. There'll be a little bit more stability. Again, this will take a long time before we see that stability, but it's coming down the road.
On that point, though, and related to, Jeff, some of your points, do you expect there to be, in particular, given the way the congressional races have played out, an effort, at least in the first 2 years of this incoming administration, to seek legislative changes in this area to adopt new statutory provisions, new laws that would supplant the need for executive orders or suspect interpretations of existing provisions?
Yeah, I certainly think there will be an effort, especially here in the first year in 2025. But remember, there's still going to be fewer than 60 Republican senators, and you still have the filibuster in place and a variety of other legislative procedural hurdles to getting to final enactment of significant reforms. And we've been through this before, where there have been efforts to, whether it's in longstanding environmental statutes or even something more recent like the IRA, it's difficult to get the votes you need to pass legislation. And the House, as it stands today, is razor thin Republican majority. I think there will be a lot of focus on the regulatory side of things, because that's where you can actually move the needle in the most reliable way. But of course, you've got to make sure that those are done with the full APA processes so that you minimize the risk of course, stepping in.
What about putting your prosecutor's hat on, or your ex-prosecutor's hat on? What are your perspectives from an enforcement lens and how that may be impacted?
Yeah, on the environmental enforcement front, we should see a return to a sort of back to basics approach at the federal level, with a focus on traditional clean air, clean water, clean land issues. The Biden administration and at EPA in particular, the enforcement program has been laser focused on prioritizing climate change and environmental justice concerns. And I suspect that we'll see a return to more traditional environmental enforcement prerogatives. If you look at the numbers, though, Michael, one of the things that people tend to follow closely is, will we see a downward trend or an upward trend in terms of the number of cases and investigations that are opened or closed? And actually, it's really fascinating. If you look at the long-term trend, going back over a decade, we've seen a fairly steady decline in the number of civil enforcement cases that have been opened or concluded by EPA, for a slight uptick late in the Obama tenure, and then another downward trend until around 2021, going into 2022, when the Biden team was able to bend the curve a bit upward. We saw a 5% increase in the number of cases out of 2023. And I think, although the numbers aren't yet available, I think you'll see that for 2024, the Biden EPA was able to continue that upward trend. And I think a question to, or at least an issue to watch, is whether we start to see that level out again and maybe continue back down along the longer term trend of reduced enforcement cases. And frankly, I think that's due in large part to improving compliance programs across industries, as well as the sort of more recent focus by EPA on the bigger cases. So bringing fewer cases, but bringing cases that are more complex and with larger consequences. So that's where things are headed. On the policy side with enforcement, things will be very different, I think. So the Trump administration, the last go around, emphasized cooperative federalism principles, highly deferential to the states, trying to take a more compliance-focused approach, pushing compliance programs over enforcement, trying to be as pragmatic as possible in terms of reaching results. And then also a narrower use of consent decrees as a means of enforcement, while also seeking to reform citizen suits that are out there. And then also, you may remember, Michael, a policy change at DOJ in the last Trump administration that cut across programs, not just environmental, but certainly affected all of the civil and criminal enforcement programs at DOJ, and that's third-party payments. I think the Biden administration was slow to roll back restrictions on the use of third-party payments or the use of supplemental environmental projects in enforcement contexts. But I would fully expect the new team here with the second Trump administration to return to restrictions on those tools as well. But I think overall, you're looking at a back to basics approach with a focus on compliance and a return to more traditional modes of enforcement.
I think a lot of that, may apply more generally across the regulatory enforcement landscape in some ways. We are happily joined by Brendan Quigley from New York. Brendan, how are you?
Doing well.
I think you joined us in time to hear some of that from Jeff related to the sort of outlook for environmental enforcement. You have any thoughts on that or how that fits into sort of the broader picture for DOJ?
Yeah, I think that's right. I think day-to-day DOJ, at the line prosecutor level, you won't see a ton of change. And I think a lot of the types of cases that have been emphasized over the last several years, regardless of the administration, will continue to be priorities of President Trump's new administration. For example, there's been an increase in investigative activity and prosecutions around export control violations and sanctions. Those areas were previously largely the province of civil regulators, OFAC in the case of sanctions, and mainly the Department of Commerce in export controls. However, we see a lot of resources devoted to the National Security Division at DOJ, and I think I would expect to see that continue in President Trump's new administration. I think you will continue to see cases focused on fairness in the markets, both at the DOJ and the SEC. Perhaps to Jeff's point on environmental, dovetailing on the more traditional types of cases that we've seen in securities fraud enforcement, whether that be DOJ or SEC. So things like accounting fraud, things like insider trading, more of a focus on public companies probably would be what I would see in terms of a shift. I'm not sure there'll be a deluge in enforcement actions in that direction, but I think a shift in investigative priorities certainly may be at hand, given kind of the idea of keeping the markets fair for the retail investor, the day-to-day investor. A third area you may see an increase in is the False Claims Act and litigation investigations around government subsidies or loans or grants or things of that nature. And I think, interestingly enough, there's a case in Florida right now, in a district court in Florida, which held that the key TAM provisions of the False Claims Act, the provisions that allow a private citizen to bring suit in the name of the government, are unconstitutional. However, that does not affect DOJ's ability to, even to the extent that cases is at all persuasive authority outside of a district court in Florida, it does not affect DOJ's authority to bring its own False Claims Act cases and investigations. So those are three substantive areas I think you will see continued emphasis in. I think on the SEC front, and Michael, we could talk a little bit about this from the CFTC front. You may see fewer of the kind of the record keeping cases that we saw in the last administration around things like phones and things like that, but text messages, record keeping for broker dealers and investment advisors. I still think at the same time, the expectation has now been created, whether it's FCC, DOJ, or CFTC, that if you are a company being investigated and you issue phones to your employees or have access to those phones, those items are going to be part of your document review in response to a subpoena or other investigative demand. Michael, any thoughts on that from like a SEC, CFTC perspective?
Yeah, I agree. Those cases have been brought. There were significant penalties and significant efforts to come into compliance by market participants. So I think that set of expectations, connection with investigation responses, is likely to remain. Although I would say where there could be a change in priority or a moderation is to the extent those types of cases are brought in more remote areas, right? The core circle was regulated entities, financial institutions, and they've been broadening that circle to look at other companies who are failing to keep records in the modern world. And I think the pressure to continue to expand that enforcement circle will be, or at least the pace of that growth, I think will shift and maybe slow. So, well, look, Brendan, let's maybe just turn to more specifically to the SEC just for a second. And I know before you joined, we had Shay talk about environmental regulatory issues, and there certainly is some crossover with what the SEC has been in terms of rulemaking and climate-related rules. And so maybe give us just your thoughts on how that may play out under a new SEC chair, and then maybe Shay, you can give us your thoughts.
Sure. So the SEC had recently adopted climate-related rules back in March after a lot of, frankly, controversy and an extended notice and comment period. And those rules required large publicly traded companies to adopt extensive climate disclosures. We may see a new commission under a new commissioner paring back those rules. That would be more in kind of the rulemaking side versus the enforcement side. I think that we would also see potentially where you have firms offering environmental friendly investment options, facing increased pressure with enhanced justification for ESG related investment decisions. President Trump pledged on the campaign trail to reinstate an executive order he made during his first term that it made it harder for employers to offer ESG funds in employees' 401k retirement plans. And I think it's likely that some of the other ESG type rules, disclosure rules that have been talked about in the Biden administration, including the human capital management rules and board diversity disclosure rules, may also fail to materialize.
What's your perspective on what you see from the SEC in terms of environmental regulations and how that may play out, crossover with what you were talking about earlier?
Certainly, there's a lot of sentiment that I think it's fair to say in conservative circles that the SEC was pushing its statutory authority when it was trying to require climate disclosure under securities law. So consistent with that position, one would expect a significant scaling back or frankly elimination of the climate disclosure rules. I certainly think that SEC is going to be headed in that direction. What does that mean for American companies? Well, that means one less agency is going to be requiring them to do that, but they still will be pushed by other agencies to head in that direction. For example, California's regulations are still out there. They're being litigated, but they're arguably greater in scope than the SEC rules would have been with respect to required disclosures on greenhouse gas emissions and the impacts of climate change on your business and vice versa. So if those survive, there's an argument that it doesn't matter because everyone's still going to have to comply with the California regulations. And of course, there's a European regulatory framework, which is also very stringent in terms of disclosure. So if these American companies want to participate in those markets, those requirements will still apply. So I think that's, again, how it's going to play out. We'll likely see a retreat from the SEC in terms of climate disclosures, but these other regulatory frameworks will still be in place, which will still push companies in the direction of disclosure.
That's a really good point. And I think from an SEC leadership perspective, we haven't seen a name put forward yet for a new SEC chair. Certainly, the two current Republican commissioners are names that I would expect are in the hat for consideration. Hester Pierce, I think, is someone who I think it wouldn't be a surprise to see certainly become the acting chair, and wouldn't be unusual to see the acting chair get the permanent nominations. Her record related to these issues is clear through her participation in the rulemaking processes and her numerous statements related to the climate-related rules and other ESG-related rulemakings. I think all that is consistent with how it would play out if she were to become the chair. There's a lot more to talk about at the SEC, including where the SEC might head with respect to crypto in light of Trump's commitment to make America the crypto capital of the world, and given the outgoing chairman's view of crypto and sort of difficulties that the SEC has had in the tough enforcement that they've taken in connection with digital assets. That's an area where I think you can expect to see change in a change of priority at the SEC, and one that, moving on to the CFTC, that I think will be.
All right, hey, one more point.
Yeah, go for it.
I think just 2 points on enforcement on crypto and cyber. I agree with everything you said, Michael, about the president-elect's statements about crypto. That said, I think it's important to note that in the last Trump administration, there were a number of the early significant crypto enforcement actions were brought, right? Kit, Telegram, Ripple. Those are all brought by the SEC during President Trump's first term. To say that, I think it's important for folks to realize that it's not necessarily an either-or situation, right? And you certainly may see an environment that's more conducive to crypto. You may see legislation around crypto. You may see a different kind of premise around crypto. Not that it's, frankly, in the current SEC regime, it's a presumption of being harmful. That may certainly shift, but it doesn't mean that the SEC will not be bringing enforcement actions where it's even warranted. And I think the same thing around cyber disclosure, right? We talked about this. We issued a client alert about it. We've talked about it in a number of other cases. There was recently an SEC cyber-related settlement where Commissioners Pierce and Urieta had a very spirited dissent accusing the SEC or the balance of the commission of playing quote Monday morning quarterback in challenging several companies' disclosures about various cyber intrusions. At the same time, keep in mind there were, in the first President Trump administration, the SEC did bring a number of significant actions, including one against a public company that comes to mind, for failing to disclose risks and other material events around cyber intrusion. So there may be a shift in emphasis, but it doesn't mean these types of cases are going away.
I think it's an excellent point, and I think it's very similar to what you were saying about environmental enforcement. I think we'll see a return to baseline priorities. Certainly, the SEC is not going to abandon pure anti-fraud enforcement, no matter what area it's in, whether it's crypto or cyber or insider trading or some other areas. And something else you said I think is important, and that's, I think, where we will see, I think, some emphasis from both the SEC and the CFTC is working with Congress to potentially clarify through legislation the jurisdictional boundaries and definitions for digital assets. There's been a number of efforts in current Congress and in prior Congresses that just haven't gotten over the line. And the alignment of interests in this new administration and this new Congress, I think there's a general feeling in the marketplace that those jurisdictional boundaries could be clarified by Congress, which would impact both the SEC and the CFTC. Now, I want to turn to the CFTC just for a second. I think we can pick up in a future show more broadly what we might expect in terms of changes at the CFTC, but in light of time, I want to keep it narrow. But I do want to focus on, given the theme of the show, what we might see from an environmental perspective. The CFTC, under the current commission, has been focused on the voluntary carbon markets and the environmental markets, and seeking to be active there. They've issued guidance related to the listing of voluntary carbon credit derivatives. They have established an enforcement task force related to environmental markets and fraud. And they've been very active in that area, including bringing their first enforcement action, significant enforcement action in that area. So consistent with the theme, I would say that I think under a new commission, whether that's a new chairman who we don't know, or whether it's one of the sitting Republican commissioners, Summer Mersinger or Caroline Pham, I think we're likely to see, again, a shift in emphasis. I don't think they will completely reprioritize their enforcement effort to ignore the environmental markets, but I think there will be a more subtle change in priorities and the environmental market enforcement in particular, while still continuing to pursue their core competencies, including fraud in whatever markets, whether it's digital asset or environmental. Shay, do you have any thoughts on the carbon markets and how that might play out from the CFTC perspective, or where there are overlaps?
Yeah, I agree with you, Michael. And I think one thing we could see that's common between what you're talking about, the CFTC, and where energy and environmental policy could be headed is a reframing of activities that are currently going on. Right now, the CFTC is framing its activities as facilitating carbon markets. And I think we'll probably see less of that. They may still, as you stated, be going after fraud in the carbon markets. And in a sense, it's the same thing, right? If you're decreasing fraud in the carbon markets, you're increasing trust in those markets. And the marketing of the effort might be different, but at least some of the activities will continue despite the administration change. And tying that back to the environmental space, it's this theme of energy dominance that I mentioned at the beginning of the call. Energy dominance is going to mean more of an emphasis on domestic fossil fuel production, although obviously those levels were at record highs even under the Biden administration, but more of a public emphasis on that. But it might also mean continued emphasis on critical minerals, electricity development, domestic sources of renewable energy, all these things that are also elements of energy dominance, and that might be consistent with some of the things that the Biden administration was doing. And obviously there's going to be a change in emphasis, a change in how we talk about things, but it doesn't mean that all these kind of energy transition, climate activities, voluntary carbon market activities, all that stuff is going to completely disappear. I think we'll see those activities in some form maintained into the new administration.
Yeah, I think that's important context for sure. Well, we are running out of time. We will certainly circle back to SEC and CFTC changes under the new administration in future episodes. But let's just recap here. And Shay and Jeff, do you have any practical takeaways that the corporate team should be considering as the new Trump administration gets formed and gets underway?
Yeah, I'd be glad to jump in there. I'd say two things. One, be engaged with both the transition process in terms of monitoring what's happening, who's taking key roles, as well as the policy and regulatory ideas that are being promoted, and then be ready to engage with new leadership as it arrives in early 2025. I think especially those who are in-house counsel, it's good to have the intel on what's happening, and being engaged and aware through your trade associations or through other efforts can really help you be a step ahead of what might happen in 2025. And then I think there's also a proactive step that in-house counsel or C-suite executives or even board members can be taking in this period of time. And that would be to evaluate the regulations that are out there that may be outdated, that may not fit the circumstances of the current economic realities that you face, or just maybe find out bad regulations that you think should be changed. And I think it's important to be ready to tee those up, and especially in an era of regulatory reform, to try to look for opportunities to elevate discussion around those issues and see if you can make progress. And that can involve the assistance of policy lawyers, your government affairs team, as well as your in-house legal team, to see what might be best to navigate those new opportunities.
That's great stuff. Shay, anything from you before we turn to Brendan?
Yeah, I think companies, particularly in the energy transition space, need to be thinking about how to reframe what they want to get done in a way that's consistent with what the Trump administration is prioritizing. Again, energy dominance and deregulation. The good news is there's a lot of things: permitting reform, again, promotion of supply chains for all sorts of energy in the United States, carbon sequestration, things like that, that this administration is going to be quite interested in, and in the long run, I think will facilitate energy transition activities. So again, I think focus on how to make what you want consistent with what this administration wants, and there'll be a path forward.
That's great. Brendan, we'll give you the last word. What do you say to internal legal and compliance teams, and what practical tips do you have for big picture takeaways?
Yeah, I think it's a matter of refocusing, and to echo Jeff's, some of the efforts may be directed now towards paying attention to legislative priorities and being less concerned about sort of regulation by enforcement. Crypto is a great example where I would expect to see more legislation and perhaps less enforcement. That said, folks need to be aware that these kind of core types of investigations, core types of offenses, we mentioned the cyber disclosure cases brought during the President Trump's previous administration, for example, those types of cases will continue to be brought. I think we will continue to see emphasis in the DOJ area in the types of national security offenses and investigations and prosecutions of things like export controls, money laundering, and know your customer, sanctions compliance. Those things all need to continue to be a focus, and may need to be more of a focus in the incoming President Trump administration. So I think it's obviously the new administration, different party, different priorities, but I also wouldn't, from a compliance perspective, I wouldn't necessarily overpromise a pendulum shift in terms of the core things that we generally tell clients to be concerned about.
I agree with that from a big picture. I would say from a more practical compliance perspective, it even points in the other direction. In a time of regulatory evolution and significant change, there's a real need to stay on top of the changes, track the changes, manage the shifting regulations, and continually assess how they impact your business and adjust your compliance program accordingly. I think a concerted effort on compliance teams and internal legal teams to really make sure that they're aware of the changes in the regulations relevant to them, and are tracking them, ensuring that you're really staying on top of them, so you're continuing to take advantage of opportunities quickly that occur, but also stay on top of compliance where those changes either impose new obligations or don't change your existing obligations so that you're continuing to maintain compliance. So we'll leave it there. That's all we have for today. Let's wrap things up. Thank you, Brendan, for joining. And thank you to our guests. Thank you, Shay and Jeff. I really appreciate your contribution. It was great to have you. And we hope you'll come back and join us in the future as we get a little bit of water under the bridge here with this new administration. So to everybody listening, we appreciate you being with us today. We hope you come back and join us for the next episode of the Baker Botts Enforcement Insider. Bye-bye.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts, LLP, for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.